big news in the world of true crime. And Alex Murdaugh, he's getting a new trial, and the new trial date has been set for April 5th, 2027. Today, we are going live and we are going to go over some of the key moments from the first hearing as we head into that second trial. All right, so we begin with how we got here in the first place. I'm going to play a report, and this is from the Today Show that aired earlier today, and it's a good overview of how we even got here in a second trial.
This morning, Alex Murdaugh expected back in a South Carolina courtroom for the first time in more than 2 years, as the once prominent and powerful attorney accused of killing his wife Maggie and youngest son Paul could get a date for his retrial.
Guilty.
It comes after his double murder conviction was overturned last month, when South Carolina's Supreme Court ruled Murdaugh's right to a fair trial was violated, citing jury interference by then court clerk Becky Hill, who the High Court said placed her fingers on the scales of justice by telling jurors deliberations shouldn't take long and suggesting they watch Murdaugh's body language when he testified.
I didn't shoot my wife or my son anytime, ever.
At trial, prosecutors painted a picture of a man so desperate to cover up financial crimes and to maintain the integrity of his well-to-do family's name that he carried out the 2021 killings on the family's sprawling ranch to garner public sympathy. But his defense has pointed to a lack of evidence, and Murdaugh has maintained his innocence even after conviction. The case has been the focus of multiple true crime docs and series.
This is the fall of a dynasty, it's a fall from grace.
Now, with a new trial on the horizon, Murdaugh's legal team is asking for the case to be moved to a new jurisdiction and could introduce new witnesses and evidence, telling this to Craig last month on Today.
Is there a new working theory about if it was not Alec, who it could have been?
We do have information that's been provided to us
Since the trial.
And there are frankly a lot of people out there who believe in Alex's innocence.
Murdaugh's lawyers have already asked the court to have unidentified male DNA previously found under Maggie's fingernail undergo an independent analysis, something the judge would have to agree to before trial, as the now 58-year-old Murdaugh, who is still serving a separate 40 years for his financial crimes, looks to clear his name of murder.
Okay, again, that's a good overview of how we got here on this Monday, June 29th, and our first pre-trial hearing, and the bombshell that we actually have a trial date. There was a lot of things discussed today. We're going to go through them, including the trial date, which could move, by the way, but they could be on track for that. DNA testing is going to be a major issue. We saw some fireworks about that in court today. I'll play it for you. Venue change, whether or not it's going to be held there in Culleton County, highly unlikely at this point in time. But let me know what you think in the comments below. And then a lot of discussion about discovery and retesting and experts. Remember, the first trial happened a few years ago, and that was that major bombshell of a lot of discovery that was dumped in the middle of the prosecution's case. And they talk about that today too. And then also whether or not, since the conviction was overturned for the deaths of Maggie and Paul, and he's being retried for those murders, those murder charges, that's whether or not he should be allowed to be in street clothes during court proceedings leading up to that second trial, so that you don't want to influence a potential jury pool. So that's something that's also going to be discussed. We have a new judge on the case. Remember, Judge Clifton Newman has retired. She welcomed everybody into the courtroom, recognizing that it's making headlines around the world, and there were a lot of reporters there that might not have been to that courtroom before. Here's what was said.
I see we have a full house. Good morning. For those of you who've never been to Lexington County, welcome to the Lexington County Courthouse.
In the matter of State of South Carolina versus Richard Alexander Murdaugh, indictment number 2022 GS 15-00592 through 595.
I've made some notes on a status conference, and I'll let y'all talk in just a little bit. But I want to go over what I want to go over. Because I want to make sure that all the discovery in this case is complete. And I made some notes, and let me tell y'all, I don't know anything about the first trial, so when you tell me something, please be complete when you tell me, because don't assume that I know, because I don't. I want to know about phone records. Do we have all the phone records, and are they complete? Text messages, cell phone extractions, and if there's any supplemental extractions, video recordings, whether there's ballistic firearms, are we complete in that? Fingerprints, toxicology. I think there was a blood splatter expert last time. I just want to know where we are with these discovery items. I'll let the state address that, please.
Okay, so that's what the main point of today was, scheduling and also evidentiary questions and where we are. The judge just wants to know who's going to be called, how much time do you need attorneys, and where can we go from here? So then first up to bat was Creighton Waters, the prosecution team. He is retrying the case. Dick Harpootlian and Jim Griffin, they're the lead counsel for Alex Murdaugh and his defense. And they were just kind of going over what sticks out to them the most. There were other things discussed. There were other files or motions filed, but I wanted to play a couple of them for you.
Yes, ma'am, Your Honor. So we have provided, and obviously provided well in advance of the first trial, very extensive discovery. I'm not aware of anything in the items that you mentioned that have not been provided to the defense. And if anything, the defense has more than the state does, because a very heavy privilege review was done, for example, on Murdaugh's phone and formally naming an attorney and that sort of thing. So it's my understanding, complete extractions were provided to them, whereas the prosecution team, the investigative team, only received the privilege review some of the extractions as it relates to this phone and that sort of thing. As always, we are constantly auditing and looking at everything, but I'm not aware of any discovery from the very extensive productions that were made, not only from just the murder investigations, but also from the very extensive state investigations as well. So we have provided those. And, obviously, I'm not aware of anything in the categories that you mentioned that have not been provided to you.
And not anything that needs to be reanalyzed or anything that the court would be waiting on?
At this time, no. Now, as you're aware, and we, of course, sent our responses to everyone last night to this defense motions that were filed late last week. Came in the office Sunday to write those. One of those is their request for independent testing on DNA. So we put it in our motion, and I actually got an email from Mr. Griffin this morning that if they want to have their defense expert reach out to SLED as to specifically what capabilities they think they have and what they're proposed to do, happy to facilitate those conversations and discuss those with the defense and then with Your Honor if necessary. Right now, that's kind of where we stand on that. And of course, any other issues that arise along those lines, we're very reasonable and we're perfectly willing to discuss those with the defense. And if there's something that we can't agree on, obviously we'll raise those to the court.
Okay.
So we don't know what we don't know. But why we didn't find out? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is not what Chapman testified to. And if Chapman has evidence, there were other people at the scene. That he had assistance under their theory, or there were other people there. We need to have that furnished to us. And we have other witnesses that testified at trial are saying something totally different, indicating there's evidence to believe that somebody else was at the scene, or there were other people at the scene. I mean, this guy's the chief guy in charge of the scene, along with Rutland, who processed it that night. We need, and we're in the process of doing this to determine if they do other statements or other reports. So we don't know what we don't know. We don't know what we don't have. We need some period of time to try to process that. And Your Honor, I say this, and no emphasis on trying to, we're not alleging that the state has hidden anything from us. We do know there were people that came to see us that said they had important information. We have no ability to investigate. We don't have subpoenas. We don't have grand jury. We don't have search warrants. And 2 or 3 of those people we sent to SLED. Did they follow up? One had extraordinary evidence about a tie-in between Paul's murder and the murder of a young man named Stephen Smith. But we had no, I can't compel anybody to come anywhere. We sent that to SLED. Did they investigate it? And they investigated, and I must tell you, there are a lot of pieces of information out there that, and maybe they just stopped once they got the conviction, didn't do anything else, that it's inconsistent with our desire to get a conviction, or have the conviction held. So they didn't follow it up. Maybe it does need to be followed up. But one of the points reminding me, we did not have OnStar data on Mr. Murdaugh's vehicle until halfway through the trial. That is not the Attorney General's fault. That is DNC's fault for not furnishing it. We had to do that on the run. We want to go back and analyze that, have an expert analyze that even more. I do want to emphasize the Attorney General got it at the same time we got it. No inference, anything improperly.
Okay.
So that's part of what we need to do. We need to hire additional experts based on some of the views we now have on some of the witnesses, both the state and the defense have. And they need to examine those reports to determine whether we have it. So it's going to take a little bit of time, Judge. I can't tell you today we have everything because we don't know.
Okay. Let me ask you, Mr. Waters, what about the OnStar data? Do you have all of that?
Yes, ma'am. So, Your Honor, we actually SLED had sent 2 search warrants to GM well in advance of the trial, and we're told we ain't got none. And I think what happened was during the course of the trial, we actually had the FBI buy a Suburban and essentially reverse engineer the black box in the Suburban in order to provide us telemetry data, which of course is all provided to the defense. I think when that testimony came out during trial, somebody at GM was watching and they were like, uh-oh. And so in the middle of the trial, I get a phone call saying, about all that OnStar data, actually, we got a bunch of it. We immediately advised the judge, advised the defense, provided that to the usual form. They assessed it and agreed to go forward because each hour of theories about what had that. So that was nothing with the fault of the state, and we immediately engaged in what we needed to do to ensure the defense had access to all that information. As to him saying, we don't know what we don't know, well, I know what my obligations are, and if I have knowledge of something that's disclosable, then it's been disclosed. And so to imply that there's something out there, I mean, we're always constantly auditing that and doing our obligations, but I take discovery obligations very, very seriously. And knows that. As far as these musings, I haven't watched this TV interview. The musings of some captain about whether the scene was clean. Well, there was evidence presented at trial that there was standing water on the concrete pad of the kennels, that the hose was not put back the way that it normally was coiled by the person who was in charge of taking care of the kennels. So he may have been talking about that, but ultimately, while Collinson responded initially, the scene actually was in charge of being processed by SLED, and they've had access to all that information. So to sit here and imply, we don't know what we don't know, well, I'll recognize that, but I know that my obligation is to provide that information to the defense, and if I'm aware of it, then it's been provided.
Okay, so there's a big takeaway right there in where this defense is probably going with trial number 2. So it's been a few years, right? And there's also new testing and new technology. And also during the first trial, they weren't adequately able to prepare, so to speak, because the GM data, the GPS data from the vehicle was dumped on all the attorneys, not just the defense, but the prosecutors midway through. I sat through that trial. I thought that was shocking when that happened, when it was admitted. And I thought that would be one of the issues, one of the appellate issues, but here we are, and the case was overturned for other reasons, Becky Hill. But what they're really going to hone in on is the DNA, the GPS, and processing the scene. And they were talking a lot today about the grand jury testimony, and the defense was saying something to the nature of they haven't been able to review it all, and their client hasn't been able to review it all. And that's why there was a fight over technology in the jail, in the prison, which is not allowed. They wanted him to be able to have a laptop to be able to review all of the trial prep documents and all of the past documents. And we'll talk about that in a little bit. But here's more about the DNA, as was discussed in court today. And it gives us a better window into what really this defense is going to be all about.
Exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab. These murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genetic genealogy was just on the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Courtroom is the leading lab that performs this analysis. They did last year on 2024, the statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho. They had a DNA sample they ran through CODIS. Came up nothing. There was nothing. The state of Idaho Police Department, like SLED, had a contract with Courtroom. They sent the test Courtroom. Courtroom does this genetic genealogy DNA analysis, and it comes back to a family member who'd done a DNA test, ancestry test, of the person who committed these murders, Bryan Kohberger. That's how they solved the Moscow murder cases, was through Courtroom lab. The difference between, and they say they don't have enough samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses analysis called STR. This analysis is SNP, and they call it SNPs. CODIS has 20 data points. SNPs has 500,000 data points that they analyze. Now, it takes a while to do that. And so, we're going to have to see what the lab says. They've asked me to get information from SLED as to, they'd like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd ask Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. And there are handfuls of labs around the country, and they are they're certified. They work with law enforcement. I don't know that they've worked specifically with SLED. They're familiar with SLED when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send.
Correct. And they can work with the extract that SLED used when they did their STR analysis. They can work with that out there that they told me. But
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED reach out and talk to them about what their supposed capabilities or proposals are and any procedures. And I'm then, once made privy to that information, I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll come back to Your Honor. That's precisely what I put in my motion is let's talk to, let the experts talk so that my experts can hear, what it is that they propose to do. And I'm happy to consider.
the DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alex Murdaugh. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential. And that potential, the ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be, innocuous. We don't know, but it's worth looking into.
Okay, I haven't said no. This is what I do want you to do, though, Mr. Griffin. I want to know how long it's going to take to analyze.
I think, again, some of the key takeaways from today is what the next trial is going to look like and what exactly the defense might look like, right? It might be much more bold and much more expert and data heavy, including what they're talking about with DNA, unknown male DNA, and having it tested by the same lab that helped identify Bryan Kohberger as a suspect in the Idaho 4 case. I mean, the fact that Kohberger was brought up today, that was huge. That was a huge, huge moment in court today. And then, when they're talking about the OnStar and the data from GM, I'm wondering what new technology we have with that. What more will that show? Or what better technology do we have with cell phone extractions? What kind of experts will we see on the stand for that? And what will that show? Who will that help? I think that is going to be a fascinating turn of events, possibly in this second trial. And then I mentioned this at CrimeCon because I was on a panel about this upcoming retrial. And I was discussing the fact that I want to know more about what happened to all the drugs, what happened to all the money, all the millions and millions of dollars that is still missing. Is it buried at Moselle? Are there more details that we don't know about? So I have all of that written down. And then I was noticing his body language and just the way that Alec was presenting in court today. Wow, he's aged quite a bit, right? I sat through that first trial. I watched him testify. No, it was not tears. Yes, it was snot. And the jurors did appear to cry and pass him Kleenex, and they were within an arm's reach of him. And that was just such a big moment of covering that first trial and something that I get asked about quite a bit. There was a big discussion today as to getting this defendant. Every defendant has a right to a defense, of course, but also every defendant has a right to participate in his or her defense. And in this case, you have a disbarred, disgraced attorney who very much acted like a lead attorney on the case the first time around. I went and I interviewed people at the courthouse, the Colton County Courthouse, and I actually did a report from inside his holding cell. And I was told at the time that he would just pace back and forth during lunch. Sometimes he wouldn't even eat, and he would just hold a big manila folder full of notes and full of court documents from his trial as he was pacing back and forth. And he would carry them to and from the courtroom and enter in as if he was just lead counsel on the case. It was just very bizarre. But so he wants to be able to review all of the documents. And there's an argument right now as to whether or not how to do that, how to facilitate that. He wanted special accommodations to have a laptop, and that brought in this discussion.
Let me talk about this computer at the Department of Corrections.
I mean, we're just basically talking about a big Kindle. You can read on it. You can't send email. It's not connected digitally or cell or Wi-Fi to anybody. It can be kept. Let me say this: the Department of Corrections has been extraordinarily professional in dealing with us, giving us access to that. but no complaints with them whatsoever. But what we'd like is we'd like that laptop with the warden and corrections to have total access to it. It can be inspected by SLED to make sure it can't transmit the image, a message, can't be used in any way. There is no Wi-Fi at this particular institution, so it has to be by self-service. I mean, these are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's a very low percent of what we want him to look at. And we can certainly do that separately with hard copy. We'd be happy to go down there and do that.
Well, let me tell you. Well, Mr. Waters, let me hear from you first.
One thing SCDC is adamantly opposed to is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that. This is an individual who was caught receiving contraband that was passed from a family member through the defense to him, found by guys. And so this is not a guy who is, and this is also a guy who's been convicted of over a decade of fraud.
And with all due respect to the Department of Corrections, if you don't get the ability, I mean, if Mr. Griffin and I, or Mr. Barber, or Ms. Fox have to go down there, 3 hours down, sit with him for 3 hours, 3 hours back, we're talking about at least the end of next year, not the beginning of the following year, to get this support. We can't be working on experts, and we can't be interviewing witnesses while we're tied to sitting there and babysitting him while he's reading a laptop that doesn't have any capability to communicate or copy.
All right, let me tell both of you. I took the liberty of calling the warden and talking to him about the laptop situation. And he will not allow a laptop. And for safety reasons. He said he would, quote, make available a conference room. Counsel may bring their computer. They could have a law clerk come.
That's basically what's going to happen if you work in that law firm. You're going to be the law clerk that has to drive to the jail, to the prison, and sit with Mr. Murdaugh as he reviews all of those court documents. So that's my guess into what's going to happen there, because Jim Griffin and Dick Harpootlian don't want to drive to the prison and spend all of that time and babysitting their client, Alex Murdaugh, as they gear up towards the second trial. So the big takeaway, though, folks, is even though he's being retried for the murder of his wife, Maggie, and his son, Paul, who was just 22 at the time, he's not getting out of prison. He's in federal prison right now, and he is there because he admitted to being a thief, to being an insurance cheat, a drug addict, and a bad attorney. He was disbarred, and he is spending 40 years, possibly the rest of his life, behind bars in federal prison. But he is allowed a process for the charges of murder, and he's going to be back in court next year to face those murder charges. And it's going to be a very, very different trial. All right, I'm going to say goodbye for now. Thank you so much, everyone, for getting into the chat. Thank you, all of those of you that have donated and helped support the show. Brandy Dog and Mad Cleary 73. Thank you so much. I appreciate it. Please take note in the video section. I have a video that's going to premiere in about 10 minutes or so. So please check it out. Again, thank you for being here. This was a recap on a pre-trial hearing for Alex Murdaugh. Have a great night.